Pinky Anand, in court, those who oppose this move say that women who are subjected to sexual violence by their husbands, they're saying that, you don't need to do all this. You don't need to change this IPC. This option is not necessary because women do have other criminal avenues available to them to protect them today. What would you say?
This is quite an ignominy, so to say. You can't say you have other avenues, therefore you shouldn't have a particular avenue which is available. The question today is, considering 375 IPC, considering that IPC itself carved out exception initially for even younger children between 15 to 18 in terms of statutory rape. Similarly, exception 2 carves out this exception for marital rape, and this has stood over the period of time. Of course, when that's right, it comes from colonial era. In fact, starting from somebody called Chief Justice Matthew Hale, right back in 18th century, and today we are somewhere in the 22nd century. So I don't know what we are really talking about on that. But the question is of having other avenues like you're talking about 498A, or you're talking about divorce. In fact, recently, I think the Karnataka High Court also granted a decree of divorce on the ground of marital rape. But the point is not that. Today, the whole question is, the law in our country says there is rape if there is absence of consent. Yeah. And if an unmarried woman is raped, the same will amount to rape. And if it is converted into a marriage, it will stop being rape. I mean, that is the real question today that does stand. Is the classification on the basis of rape, which can withstand the scrutiny of law?
Yes. So in a sense, you are really continuing the argument of Joseph Shine. You are really continuing an argument where adultery was an offense because you said that a woman was a man's property. So if another man had sexual relations with her, then he was guilty of adultery. So similarly, the actual original concept was that a woman was being treated as an extension of the man or the man's property. But so therefore, if we look only from Joseph Shine viewpoint and what the law laid down there, then it's bound to be struck down. But there is a very important question which the court is asking, and which is the question we have to ask ourselves. Can the court legislate? Would it be a new offense in the Indian Penal Code? Would this be indirectly legislating, and is that going to be a reason why the court may be shy of interfering? Because what the question the court has put to the petitioners is this: tell us cases where offenses have been added by the courts in the penal code. Now, the arguments that have been made by all petitioners, and which is a very attractive argument, but may be difficult to answer this question, is this: that we are only saying strike down this exception because it falls foul of Article 14, 15, or the dignity of a woman. And since this is in its own way an exception, if you strike down this exception, you make a married woman equal to an unmarried woman, equal to a live-in partner, equal. But again, the courts have only asked this question, to which the answer can perhaps be the law. As Pinky said, in 1991, House of Lords said the same thing which had been said, say, in 1876 earlier, and which was turned down and turned around. And the House of Lords says in R versus R in the UK that, look, we cannot but not accept this argument. It was a case of attempt to rape, and the wife was making this allegation. And the court said such an argument in today's day, when men and women are equal, cannot be made. But then the devil's advocate will say, should men have the same right?